Okay, good morning, everyone. Uh, Happy to see you guys here on a Saturday morning. My name is Martin Hoffman. I'm the judge of the 68th Court. I'm excited to introduce all the speakers and thank everyone who has been so integral in getting this seminar put together. This is really a labor of love, putting this together. You can imagine putting together a seminar like this that has so many moving parts. It takes a lot of talented lawyers and others who have helped put this together. Uh, we have a committee that has been meeting over the course of the last 9 months to put this and other seminars together. This is the second in a three-part series. And I want to start off by introducing them and thanking them for the incredibly hard work that they've done in putting this together. We have a couple of fantastic co-chairs who have put this together of the Trial Skills Boot Camp. We have Chelsea Hilliard and DeBron O'Neill, who you're going to see more of later, who have spent countless hours putting this together. We also have some very talented vice chairs who've been integral in different parts of this program. We have Baird Armbruster, Nicole Plagins, Alex Reisinger, and Monica Gadicio, who have all worked just incredibly hard in putting this together and kept this program going. We've also had a lot of other members of this committee who have helped in different ways and have been in a lot of different meetings and helped with different components of putting this together, including one of our newest members, Miriam Safari, Jason Borstein with the Dallas Trial Lawyers, Julie Christensen, Amanda Saputo, Brittany Prince, Chris Arnold, Andre Contreras, Robert Crabtree, Haley Jones, and Callie Franks. This program doesn't exist, obviously, without the support of senior lawyers who are going to be evaluating many of you later and giving you guys some great feedback. We have a couple of other judges besides myself who are going to be involved in that, including my neighbor, Judge Bonnie Goldstein. I hope she's on right now. She just does a wonderful job in helping out with this committee every year. We also have Judge Audrey Moorhead from the criminal courts, who is going to be one of our senior lawyers who are going to be evaluating. I'll just do a quick run through some of the other lawyers who are going to be helping out later on today, including Steve Aldis, Amy Stewart, Mike Moore, Sean Thompson, Sarah Rogers, Heather Long, Scott Palmer, Melanie Oken, Chrissy Castle, Pat Montes, Michael McCabe, Vanessa Griffin, Paul Janender, Mark Cass, Zeke Fortenberry, Alex Moore, Mark Johansson, Anne Marie Arcadia, Lance Curry, and the person who actually helped found this program many years ago. He and I have worked together on this program for quite a while, Jonathan Childers, who came up with the brainchild from this program initially. Now, our first portion of this program is going to be a panel discussion. We have some really fantastic speakers. I've been involved in this program for a long time, and I think this is one of the best panels we've ever had. Of just fantastic. You're going to learn so much, and you're going to, I think, really be entertained by our speakers. First off, we have Judge Maricela Moore. She's the presiding judge of the 162nd Dallas County District Court. She's another one of the civil district judges. She's also the presiding judge of the Civil Jury Services. In 2019, she was named the Dallas Judge of the Year by the American Board of Trial Advocates. Prior to her judicial service, Judge Moore practiced commercial employment litigation with an emphasis on contract, trade secrets, and non-competition agreement issues. She has served as president of the Dallas Hispanic Bar Association, the Dallas Hispanic Law Foundation, and Mexican American Bar Association of Texas, as well as on the board of the directors of Dallas Bar Association. She's board certified in labor and employment law by the Texas Board of Legal Specialization. If we were all here, we'd give you a big clam, but let's do our practice. Let's do this, which is how you're supposed to clap on that's what I've been told. Our next speaker is Laura Benitez Geisler. I always love telling people this. We are from the same high school down in Corpus Christi, Carroll. She is a partner at Summerman, McCafferty, Casada, and Geisler. After graduating from the University of Texas at San Antonio, she earned her law degree at Southern Methodist University back in 1997. She is driven by her passion to help others. She's practiced for 21 years and is focused on representing individuals in a variety of personal injury and wrongful death claims. Throughout her career, she's also performed significant leadership roles in the Dallas legal community. She was the 110th president of the Dallas Bar Association and the first Hispanic ever to assume that role. She also served as president of this organization, the Dallas Association of Young Lawyers, the Dallas Women Lawyers, and when she was co-chair of the Equal Access for Justice campaign, she raised over $1.1 million. Let's give Laura a big round of applause, like this, or however we want to do it. Okay. All right. Next, we have Leon Carter, who is the principal of Carter Arnett. He has over 25 years of trial and litigation experience. He is one of his biggest claims to fame is he was named the Trial Lawyer of the Year by the Dallas Bar Association last year. I've seen Leon many times in court. He's an amazing lawyer, as are everyone else here. He is a fellow of the American College of Trial Lawyers, the International Society of Barristers, the Litigation Council of America, and the International Academy of Trial Lawyers. He's been named by the Dallas Business Journal to the Defenders, one of the top 15 business defense lawyers in the DFW Metroplex. Let's give Leon a big round of applause. And finally, we have Chris Hamilton, who has established himself as one of the leading high-stakes trial lawyers in the United States. Chris has a track record of verdicts and settlements that are setting marks in both the personal injury arena and complex business disputes. For example, Hamilton was recently featured in the Courtroom View Network's list of most impressive trials of 2019. In 2014, he was recognized by the Dallas Business Journal as having the largest jury verdict in Texas for a personal injury case, and the 17th largest verdict in the United States. In 2016, was recognized for having the top verdict by Top Verdict as having the 9th largest personal injury verdict in Texas, and has had a number of other very large verdicts over the course of his career. Let's give Chris a big round of applause. And now let me just kind of explain what's going to happen next. I'm going to turn it over to Judge Moore, who's going to moderate this. You'll see on the bottom of your screen, there's a Q&A function for those of you who are not familiar with Zoom. Please submit questions throughout the course of this. After the panel discussion, we're going to be asking any questions that are asked. I will ask the panel about those questions, and then there's going to be a mock opening statement where Mr. Hamilton and Ms. Geisler are going to be up against Mr. Carter and some great and very interesting opening statements, and then we'll have some questions from the audience then too. So please use the Q&A function. It's a great way to communicate and get your questions asked. Judge Moore, I will turn it over to you.
Thank you, Judge Hoffman. And I want to echo what Judge Hoffman just said regarding the amazing attorneys that we have with us this Saturday morning that I think have so much to teach lawyers about the art of advocacy. I think that these three people are really going to demonstrate in their mock openings kind of what they do in order to be so persuasive to juries. But before we really get there, I want to ask, and Leon, I want to start with you. As you're preparing to give an opening, can you talk to us a little about what your intention is? I mean, how do you know what you're going to present before you even have your case, the story you tell, or what goes into the organization of your opening?
Well, I think what I try to do, as you know, the facts are the facts. And, you know, the plaintiff is going to have his or her version of the facts, and the defendant is going to have his or her version of the facts. What I try to do is tell a story about my client that everyone can relate to. A story cannot be controverted. My client's personal story is something that I try to get to resonate with the jury, to let the jury know that my client, whether or not that's an individual or a corporation, and I tell people all the time, a corporation is made up of individuals. And so you have to debunk the notion, if you're representing a large corporation, that is a small plaintiff against a corporation. It's an individual against an individual. And whomever I'm representing in that corporation, I'm telling that person's story. And if it's an HR director that terminated an employee, I'm going to tell that HR director's story. If it's an employee who signed a contract on behalf of the corporation, the vice president or the CEO, I'm going to have that person as my corporate rep, and I'm going to tell that person's story, how that person became the CEO, what that person had to do to make the advances that he or she made. And everyone can relate to a story because everyone has a story. Everyone is not at the same place, and everyone didn't start at the same place, but everyone is fascinated as to how people did or became what they became. So I try my best to tell a story that is going to be moving, that everyone can relate to.
I think that's a great point. And lawyers who are able to engage the jury from the beginning, who do that, kind of bring them in, are persuasive throughout the case because, like you said, people like to hear stories, and particularly if you have a jury that is sitting there, you know, there is somewhat of an excitement when the case starts because they don't know what's coming, other than, you know, a little bit that's told in voir dire. So, Chris, how do you do that in a way? Tell us a little bit about how you frame that from that first moment that you start to introduce the story that Leon just mentioned to your jurors.
Great. Thanks, Judge. And thanks for having me this morning. I'm thrilled to be up and that everybody's paying attention early on Saturday morning. I think the plaintiff's approach is a little bit unique, particularly in a personal injury context, because we are dealing with some strong societal biases and information that people may have about a personal injury case. And the approach is definitely to tell a story, but the first thing you have to figure out, in my experience, is what the frame or the framework is going to be for that story. Fundamentally, here's what this means. If we want to get a large verdict in a personal injury case where we're asking the jury to give an award against a corporation or an insurance company or an individual to an individual that's been injured, we have to give the jury a framework for them to understand what the jury's role is in the process and how the case affects the jurors. Fundamentally, all people make decisions, whether at a conscious or subconscious level, based on how things are perceived to affect them. And so what we have to do as trial lawyers is to give the jury a framework for what they're being asked to do. What is the question in the case? Why am I here as a juror, and what is my role? And so when I'm preparing an opening, before I'll write the story, before I'll prepare an exhibit, before I'll work on a PowerPoint, the first thing that I'm going to develop is what is my frame in the case? What are the first sentences that are going to come out of my mouth? What is the question that the jury is going to be asked to answer in this case? And I, through trial and error, with an emphasis on error, have learned that that first piece of setting the frame, what the question is that the jury is going to answer, is the single most important thing that I can do in the case. And if I don't set that frame early on and before somebody like Leon Carter stands up to talk, and I'm in a personal injury case, I'm cooked. And so we do that through focus groups, through talking to people. But I think it is critical before you get too far into the weeds of your case that you set the frame that gives the jury the framework for what they're going to be asked to decide in the case in a way that is persuasive as to how it actually impacts the jurors and is important and rewarding and meaningful that their participation in the process.
Tell me, Laura, a little bit. So, I mean, I think those are really great points. And I think for lawyers who have not done this as many times as the three great lawyers that we have with us today, that preparation, that organization, Chris, like you mentioned, where you really have to be thoughtful about it, is so important. So Laura, as you're doing that and you're preparing and organizing it, how do you ensure that you communicate persuasively and you engage the jury so that they know what you're talking about is going to be important to the case? How do you focus the jury in that way?
Well, I think it's important because, you know, by the time you get to trial, you've been living and breathing and you know your case, or you should know the facts of your case in and out, but the jury doesn't. They're coming to it completely blind. And so you have to make sure that your story, the frame that you set, it's simple for them, it's simple enough for them to appreciate and understand without knowing all the details. And you don't want to inundate them with so much detail about Mr. Smith, Mr. Johnson. They're not going to know who all the players are necessarily. You want to set the framework and give them a roadmap of where you're going to go with your case and the evidence and the things that you want them to be paying attention to throughout the trial. So you want to let them know where you're going so that they come along with you. And I think that in establishing that, you've got to just do it in a story-like manner so that they're interested and engaged. You want to let them know who the characters are, who the players are, and tell their story and what you expect that the evidence will show that will be revealed through those stories, and let them come along with you. Give them enough that they're interested and they're going to be invested and want to hear from so-and-so witness and so-and-so witness, because you whet their appetite of what they're supposed to say and how that's going to establish your case. You also want to be sure that you're aware and ready to preempt whatever you think the defense is going to say, because you want to make sure that you don't lose your credibility and the jurors don't feel like you're hiding something from them by not mentioning an opening. If you've got a big, if there's a big defense that you fail to address and kind of nip in the bud, you don't want it to come out for the first time in the defendant's opening from the plaintiff's perspective. So you want to make sure you address that, establish credibility, don't oversell your case, don't make promises you can't keep if the evidence doesn't come in, and just it's your first chance to make your first impression, and that's really important that you kind of establish your credibility, set the framework, let them know where you're going and what to be on the lookout for.
So, Leon, I want to ask you, because I know we've had this discussion about how much of it is setting that framework and introducing, and where do you draw the line between that and starting to argue your case, which is an art, because you do want to engage the jury. You want to make sure that you have their interest, but how far do you go in introduction and not argumentation?
Well, that's a fine line, because, I'm an advocate, the plaintiff's counsel is an advocate, and unless you show the jury, and I tell lawyers this all the time, especially from the defendant's perspective, unless you show the jury that you believe in your case and you believe in your client, and you can only do that as an advocate, you start out behind. I've seen so many times when I go to see someone else, and I still go look at other lawyers, great lawyers, try cases, because I'm still learning. I'm still doing things a little different. But I see so many times when I see an opening statement, I see one side just reciting facts and one side telling a story. So the story is important. And sometimes opposing counsel, if you go too far over the line and start making argumentative statements in your opening statement, they will object. But 9 times out of 10, a judge is going to say, this is opening statement. Or if they do sustain the objection, you just say the evidence is going to show this. But there's indeed a fine line between just stating the facts and telling the story and not being an advocate. Because I think at all times, from voir dire to the end of the case, whatever side you're on, you're an advocate. And I think you have to show the jury that, because if they don't see that, if they don't see that you believe wholeheartedly in your case, then you're not going to win.
Yeah, I think that's actually a really good point. The jury, even in mannerisms, will read from the lawyers how persuasive and how much they believe in their case. And one thing I have seen, and Chris, I want to talk to you about this a little bit, is one of the biggest errors an advocate can do is oversell the case, like Laura said. You never want to say the evidence is going to show that there was a witness that is going to confirm what Mr. Johnson says, and then there's no witness.
Yes.
Perhaps there's a logistical error, he can't come to testify. And it's interesting, the jury will pay more attention to what you don't show sometimes than what you do. So Chris, how do you do that in your openings to ensure that you limit yourself to just the facts and you don't get into argumentation that may come back to get you in the end if you were not able to establish something that you may have argued in the beginning?
I think this is a critical point, and it's one of the real arts of opening statement. I think it's also a little different for a plaintiff than a defendant, particularly in a personal injury case, again, because as I mentioned earlier, there are some biases and feelings that jurors have coming in. A plaintiff's lawyer has to be very careful not to put their credibility too far out there or appear to be advocating too early in the opening until the juror has started to develop a feeling about what they think happened. And so from most of the great plaintiff's lawyers I've seen, what they will do is tell a story that has advocacy and how they frame the facts, which facts they talk about, what they use, but they restrict the use of adjectives or pejorative type statements early on until the jury is starting to make up their own mind. There is something very powerful in psychology known as confirmation bias. And this is one of the most powerful tools for an advocate to be aware of. As a plaintiff, you can take advantage of confirmation bias by telling a factually neutral story, but which is targeted in a certain way so that a juror starts to make up their mind about what happened. And then by the time you start to argue and advocate more directly, the juror is prepared for it and they agree with you. So I think you've got to be very careful as a plaintiff not to get there too early. I think it's a little bit different for a defendant because there's a lot of data in psychology that says that counter arguments are more persuasive than arguments. Jurors, once they've heard an argument, they want to hear a counter argument, so the jury is more primed by the time the defense stands up. But as a plaintiff, you have to be very careful to make factual statements that you know you can prove, minimize adjectives, minimize pronouns to make sure that the jury understands what you're saying, and don't use complex words that turn people off or that distract people because they don't know what you're talking about. But it is critically important as a plaintiff to make sure that everything you say you can prove, because credibility is much easier lost than earned, and you have to earn it through the process and be careful not to give it away.
Judge, can I speak to that?
Absolutely.
And I understand what Chris is saying. As a defendant, though, because the plaintiff goes first, and because that is such a huge advantage to go first, because as we know, people believe what they hear first. And so if I, as a defendant, if I don't get up and use adjectives and use the tone that I believe in this and what that plaintiff just said, we're going to show you, even though we don't have the burden, we're going to show you that he was speeding or he is not telling you the truth. Unless I do that, I'm going to continue to be behind, because I cannot let the plaintiff frame the issue in voir dire and an opening statement without me starting to attack that. So I think as a defendant, it's a little different.
So Leon, as you're doing that, do you think it's important that you bring the juror in so that the juror feels your story? Since the plaintiff has gone first and has kind of established it, how do you make your defendant's story personal to the juror so that they are now coming along with you?
Okay, well, you're going to see a little bit about that in about 30 minutes. You're going to see that in a little bit. But that is definitely the key.
You got to wait for the show?
That's right. That's right. I mean, I have to do that. If I, as a defendant, if I don't get that juror and put that juror in my client's position to say at the end of the trial, what the Queen did in this case, what Mr. Shufflebottom did in this case was the only reasonable thing that could have been done. If I don't do that as a defendant, I have failed my client. And so that's my job in my opening statement, to put each and every juror in my client's seat to say, you know what, if it's a wrongful termination case, you know what, based upon the evidence we heard, the defendant had to terminate this employee. Based upon the evidence that we heard, the CEO couldn't fulfill the contract because of what happened. If I don't do that, then I've done my client a disservice.
So I agree with what you said, and I'll tell a quick story. So there was a very seasoned attorney that was trying a case in my court, and he took the juror instruction, which says, the first one you read, do not let bias, sympathy, or prejudice play any part in your deliberation. And what he said was, the judge said you cannot let sympathy play any part of your deliberation, but you can be empathetic. And took that and then said, you know, and tried to make it personal. I went, hey, I mean, I guess technically there is a difference between sympathy and empathy. But I make that point to reiterate what you just said, is you have to make the juror feel some ownership in the story, some relationship with the story.
And I can tell you another thing, Judge, that I do. You will have in your instructions that, you know, we want 12 fair and impartial jurors. You know, all judges say that in their instructions before the opening statement.
Sure.
And I will get up and I say, you know what, ladies and gentlemen of the jury, respect Judge Moore, love Judge Moore. And she said that we wanted 12 fair and impartial jurors. And I agree with that to a point. You know what, you can be partial to the plaintiff. You can want to take plaintiff home with you. I just need you to be fair. And you know what, ladies and gentlemen, if you look at the evidence and you're fair, we're going to be okay.
Well, this is the reason why we have these three lawyers that are giving their tricks of the trade to us this morning. Because even the way you say that, you can see that in the way you do it, the delivery is so persuasive because it's an art.
Yes.
And I'm hoping that the lawyers that are part of this trial skills will recognize by watching you all that it's not just a script you write on paper. It truly is an art form to take that story, whether it's the plaintiff or defendant, and to create, an art of persuasion, recognizing that you are bound by rules of procedure that prohibit certain kinds of persuasion, but doing it in a way that really does bring in the jury. Laura, I want to ask you, you from the plaintiff's side, how do you think you develop that relationship with the juror so that they do believe you? Because I think that all of you have mentioned that credibility is critical. Because if a juror doesn't believe you, and I hate to say it, but if a juror doesn't like you, a
Yes.
juror is not going to listen to you. And that may not be what everyone wants to hear, but you have to establish that relationship. So Laura, what do you think is a good way to do that as you begin your opening?
Well, I mean, I think there's some of it's just a chemistry, and you can kind of feel it. It's sort of an intangible. You got to look them in the eye. There's that sort of connection, just that chemistry you feel in the courtroom. You start with that. And then, you've got to clue in on body language. There's the subtle things that it's really kind of hard to explain. But if you're paying attention and you're looking to the reaction, the facial gestures, and responding to it in real time, if you're kind of getting a negative, reaction to something, you got to be able to adapt. If you notice that whenever you use a certain word or describe a person or a witness, characterize something a certain way, and you're getting a bristle from a certain juror, maybe that's the wrong, maybe there's something that triggers a reaction. That word is not a good word to use. And there's little things like that that just really require you to be present and paying attention to your audience and not just looking at your script. There's something very organic about it that's really hard just to say this is the formula for it.
Well, and I think that's a really good point. You have to be present in the moment. And like you said, you have to be flexible with how the jury is reacting to your presentation. One other thing that I think you'll see for those of you who are observing the openings that are going to start in a couple minutes, I think it's really important for lawyers to embrace what they are and how they are persuasive without trying to be someone else.
Yeah.
So for example, when I was trying cases before I was on the bench, I recognized I'm a petite, 5 foot tall, I don't have a big accent. I wasn't, the big Texas kind of a lawyer, but I embraced that the jurors would relate to me because I came very prepared. I was presentable. I was approachable. And so each of you all, I think it's going to be a fabulous opportunity for the lawyers to watch how you take who you are individually and use that to your advantage, because that sincerity, you can't buy it. You cannot buy it from a juror. You have to be sincere in your presentation.
Can I speak to that? Can I speak
Yeah,
to that?
I was going to say, Leon, I wanted to ask you, have you had to learn what works for you? And I mean, I'm certain it always did, right, Leon? Because none of y'all have ever made any mistakes. But
yeah, that's right. When I was at the DA's office, my first 5 or 6 trials, I lost. Not guilty, not guilty, not guilty. And I had one of the chief prosecutors, George West, I never forget this, come in and watch me in trial to see what I was doing wrong. And of course, I got another not guilty. And then after the trial, I said, George, what did I do wrong? He said, you're not being yourself. I'm like, wait a minute. What do you mean I'm not being myself? He said, I know you and you're not being yourself. And I said, George, you know what? You know me. Those 12 people over there, they've never met me before. How do they know I'm not being myself? He said, because you don't come across as authentic.
Exactly.
You're trying to use big words. You're trying to be someone you're not. Just be who you are. If you're a country boy like you are, just be a country boy. And the jurors can understand and see that, and they will appreciate that. I hadn't lost too many trials since then, because whoever I am, that's who I am. What you see is what you get. But so many lawyers want to try to be someone else and do something. And one other story. There was a guy when I moved to Dallas, the Bible Belt. There was a guy, Caucasian male, had a long ponytail. And I'm like, this is the Bible Belt. This guy's he's a defense attorney. I said, the jurors are not going to like this. And then he yelled at the police officers. He screamed at them when he cross-examined them. Not guilty, not guilty, not guilty. So I asked one juror one time, a female. I said, this guy was rude to the police. I want that guy representing me. He goes for the juggler. She said, I want someone who believes in me and who represents me. And I've learned from that, and I've tried to do that on every one of my cases. I want to believe in my case and believe in my client. And if you don't, it's amazing how people who you've never met can tell that you're not being authentic and can tell that you don't believe what you're telling them. It's amazing.
Well, I hope that all of those that are watching took two really important points out of that. One, the authenticity, but two, I think as trial lawyers, we learn more from our losses than from our victories.
Yes.
I 100% believe if you ever meet a trial lawyer who's never lost a case, that is not a trial lawyer.
That's right.
It takes real getting out there, trying new things, figuring out who you are, and losing to really establish that art of trial work. So I love that that honesty of acknowledgement that, you know, this is something that takes years to perfect. Don't be afraid to make mistakes, get back up there, try different things. And once you find your comfort zone, just stay in it.
That's
and
it.
Use that to your advantage.
Yes.
So I love it. I love all the comments. If anything else from the panelists, if you want to point out before we get started, I think everybody's ready to see the show start. What do you?
I'd like to add one thing, Judge, if you don't mind, on the sincerity targeted, particularly at some of the younger lawyers. One of the things that I think is so important as you develop your approach to trying cases, and it begins with the framing, is to find something that you really believe in. I don't really think that I have any special persuasion skills, but I feel like that I am a person that can fight for things that I truly believe in.
Yes.
And so that's important in your case preparation. If you don't believe it, the jury ain't going to buy it, period.
That's it.
And the thing that is so important for young lawyers is I read a lot of Clarence Darrow closing arguments when I was in law school. And when I first started trying cases, I wanted to be Clarence Darrow, like my words were going to be recorded forever. I was Cicero or something. And then what I realized is I get better verdicts if the jury doesn't necessarily think I'm the best lawyer in the courtroom. They just think I have the most righteous cause in the best case.
Yes.
And so it's okay if you don't appear to be a slick lawyer. It's okay if you're out-talked by the other side. If you have the winning argument, if you have the facts on your side and the jury knows that you really believe in your heart what you're saying, there's no substitute for that. And so it's a real, it's liberating when you realize that you can fumble words and you might increase your effectiveness. You can stumble a little bit. It's okay. As long as the jury knows that you're really sincere, you're going to tell them the truth, and you believe in what you're saying, that's going to go a long way. And it actually makes giving openings and trying cases a lot easier if you don't try to worry about impressing anybody.
That's
and
right.
you just try to say the truth that you know and you've developed and framed through your preparation.
And I can say, Chris, in the last trial I had in a trademark case I just had in Sherman a couple of months ago, I'd never tried a trademark case, and the opposing counsel, the plaintiff's counsel, was a trademark lawyer. And I told the jurors, just like you said in opening statement, I said, ladies and gentlemen, jury, I said, I've never tried a trademark case. Mr. Such and Such is the expert. He's tried the trademark case. I said, you know what? But at the end of the day, that's not going to matter, because what's going to matter is this, this, and this, and he can't prove it. So I was vulnerable and just let them know I'm not a trademark lawyer. So if I made mistakes, overlook it, because this is not what I do. But I was transparent with that, and that was very important when we talked to the jurors after.
So we have a question from one of the attendees, and I'm going to throw this out to all three of you, and someone can take it. What do you do with your bad facts, right? So Chris, you said, if you've got a winning case, you're going to win, which is true, except we all know if all cases just had one side, we wouldn't have jobs, right? All cases have good facts and bad facts, and you have to use them to your advantage. So, what do you do with those bad facts?
I have strong feelings about this, and I know everybody else will too. As a plaintiff, one of the things you have to do with your frame is to set a frame that makes your bad facts strengthen your case. And you have to, as Laura mentioned, as a plaintiff, you have to bring out all of your bad facts in the plaintiff's opening so there's no surprises when the defense gets up. But what we're really working to do as a plaintiff is to try to take what we think are the defendant's best facts and prepare a frame and give an explanation to the jury so that every time the jury hears those worst facts, it's actually driving a bigger verdict in the case. So you use the defendant's best facts to inflame the jury. And if you can really set a good frame early in the case, a defense lawyer, even a really good one, may not realize that when they're hammering what they think is their best point, that it's making the situation worse. And I'll give a short example. I tried a medical malpractice case a few years ago where a breathing tube had become dislodged and a patient had a horrible brain injury. And there was an air leak on the breathing tube before it dislodged. And the defense was the air leak didn't matter. It was a sideshow. You can ignore an air leak. It's not significant at all. Our framing in the case was a doctor is never allowed to ignore or abandon a patient in potential danger. And so then every time the defense lawyer said you can ignore that fact about the air leak, the jury became more upset that the defendant was advocating that you could ignore an air leak because we had evidence that that was dangerous. And so if you can set a frame that makes those facts help your case, that's the gold standard for how you deal with bad facts. But you cannot ignore them or run away from them and allow the defendant to surprise the jury with bad facts when they get up in their opening.
Yeah, you just have to acknowledge them. I mean, and they are what they are. You have to just accept them, but just explain why it really doesn't matter. Yes, that bad fact exists, but that's really not the issue. The issue is this. And this is what, you know, the real important point is. That's just noise. I mean, however it is, you just have to acknowledge it, address it. Yes, that'll come up, but really this is the real issue here.
And I agree with that because I think as a defendant, I mean, if either side didn't have bad facts, the cases would be resolved. So there are bad facts on both sides. And, you know, as a defendant, a lot of times the plaintiff is going to bring those out in opening statement about my bad facts, the defendant's bad facts, and then I'm going to concede that. And I tell my clients all the time, you know what, when you concede or accept responsibility about doing something wrong, a juror appreciates that. You know, it's when those defendants get up, we did nothing wrong, everything was right. No, sometimes we did something wrong. You just have to be able to explain it.
I think those are great points. We have quite a few questions. I think that we could sit here and listen to you guys give us tips all day long. But in order to stay on agenda, let's go ahead and get started with the openings. Perhaps if we have time after, we can hit some more questions. But
Great.
All of these tips were fabulous. I know that everybody is taking lots of notes because you guys have so much to offer, but we want to see you guys in action. So Chris and Laura, you're going to begin by giving your opening statement. Let me know when you're ready to proceed.
May it please the court.
You may
Ladies
proceed.
and gentlemen of the jury, this is a big and important case, but it's a simple case. The question you will decide as jurors in this case is whether anyone is above the law. No one is ever allowed to use a car as a weapon. No one is above the law. Now let me tell you the story about what happened in this case. It's January 2020 in London, England. The Queen is reading British gossip headlines about her grandson, Prince Larry, and his wife, Regan, who have decided to leave the royal family. The Queen orders her staff to schedule a trip to the United States so she can get away from the endless news coverage of what the British tabloids are now calling Brexit. A few weeks later, it's February 15th, 2020 in Dallas, Texas. The Queen has come to town for the grand opening, a ribbon cutting ceremony at the grand opening of an English department store. As the Queen walks up to cut the ribbon, she recognizes a couple she did not expect to see. After the Queen cuts the ribbon, she turns and whispers something to her chauffeur, Georgie. The Queen and Georgie leave the ribbon cutting without saying another word. Georgie, the chauffeur, drives the Queen to the Ritz-Carlton Hotel, where the Queen is staying at the penthouse suite. The Queen tells Georgie that she wants to go to the bar. Around 10 p.m., Georgie notices the Queen's slur is in full form. The Queen answers a question from Georgie with the name Reagan a bit too loudly, and the Queen notices some guests in the hotel bar turn and look up. The Queen sees one of the guests walk over, and the Queen hears the guest say that she was at the grand opening earlier, the ribbon cutting ceremony, and that the guest noticed that the Queen didn't say hello to her grandson, Prince Larry, and her granddaughter-in-law, Reagan. And the guest asked the Queen if the Queen is upset about Brexit. The Queen turns and whispers something to Georgie again, this time louder than before. Georgie tells the Queen no. Georgie tells the Queen he is too drunk to drive. The Queen says she wants to drive. Georgie says, Queen, ma'am, you have had way too many drinks. You don't have a license to drive in the United States, and you can't possibly drive in America on the wrong side of the road drunk. The Queen insists that she wants to drive. Georgie and the Queen walk out to get the car, and the valet questions whether the Queen is safe to drive and offers that the hotel's driver can take the Queen absolutely anywhere she needs to go. The Queen gets behind the wheel of the Royal Rolls-Royce on the right-hand side. For 17 minutes, the Queen is making only right turns, hugging the curb, circling the block. The Queen turns right onto Cedar Springs Boulevard. The Queen drives down and stops at the red light at Pearl. The Queen recognizes a British Aston Martin sports car speeding through the intersection on a green light. The Queen presses the gas all the way down and braces herself. The Queen drives through the red light without touching the brake, without turning. The Queen braces herself as the Rolls-Royce hits the driver's side door of the British sports car. After the cars come to a rest, the Queen gets out from the driver's seat and yells at Georgie to get in the driver's seat while the Queen gets in the rear passenger seat. When the police arrive, the Queen hears a neutral, independent bystander explain to the police that she saw the Queen behind the wheel of the car. The Queen tells the police that she can't answer any questions because she's having difficulty breathing. The police ask the Queen politely to take a breathalyzer test and a drug test. The Queen refuses to take a breathalyzer test or a drug test, claiming, quote, "Do you know who I am? I am the head of the Commonwealth and the defender of the faith." The victim, who was driving the other vehicle, is transported to the hospital in an ambulance. Georgie and the Queen are placed under arrest. The Queen is charged with driving while intoxicated. The victim suffers a debilitating back injury and a horribly disfiguring facial scar that ends his promising career. Who was the victim? The Queen's grandson, Prince Larry. We are proud to represent Prince Larry in this negligence and gross negligence case against the Queen of England and her chauffeur, Georgie. Now, why are we here? This is a straightforward and simple case. Why are we here? The evidence will show that the Queen believes she is above the law. That's why we're here. In the United States of America, cases like this are not decided by kings and queens. They're decided by jurors like you. No president, no governor, no judge, or international body can hold the Queen of England accountable for her lawless conduct. Only you 12 as jurors. That's why we're here. We are suing the Queen for violating 3 important safety rules that protect the public from danger. 1, all drivers are required to stop at red lights. This is a basic rule that applies to all drivers on the road. Running red lights is very, very dangerous. Any driver who does not agree to follow this rule is a danger to everyone on the road. How do we know the Queen violated this rule? This here is a statement from the official crash report. There was a police investigation. And I know that a lot of folks have strong feelings on different sides about the police these days, but I'll tell you one thing that we never hear anybody complain about is the police's role as independent accident investigators in crashes. That's a very important function, and everyone agrees that the police do a great job in accident investigations. And the police report finds that Schmidt, the eyewitness, described Unit 1 disobeying the red light. And we'll see in a minute here, Unit 1 is the Queen's vehicle. This was, as the police report indicated, verified also by videotape evidence. The Queen's Rolls-Royce ran the red light. So we know that the Queen's Rolls-Royce ran a red light. Let's go to the next rule. This is a very important rule. No one is ever allowed to use a car as a weapon. No one is ever allowed to use a car as a weapon. Folks, road rage kills. A driver is never allowed to make driving decisions based on anger. Certainly, a person is never allowed to recklessly cause their car to hit another vehicle. This type of behavior endangers not only the intended victim, but every innocent woman, man, or child on or anywhere near the road. In many ways, a car used as a weapon is even more dangerous than a gun. So how do we know the Queen violated this rule? The official crash report from the police department finds contributing factors. Unit 1, the Queen's vehicle. And in addition to disobeying the red light, driving while intoxicated, item 73 is road rage. The police determined that one of the contributing factors to the wreck was road rage. And we know the Queen was already at her hotel for the night. There was no reason that she needed to drive. She's the Queen of England. Anybody she can get a ride anywhere she needs to go. There is no reason at this time of night for the Queen drunk to be behind the wheel of a Rolls Royce unless she is intending to do something with that vehicle. And the police were able to determine through their investigation that road rage was a contributing factor, and the Queen attempted to use this vehicle as a weapon in a way that is extremely dangerous to the public. Rule number 3, and the most important rule, if we can go to the next slide, the most important rule that makes all of the other rules make sense. No one is above the law. None of the rules we've talked about running red lights, drunk driving, using a car as a weapon mean anything if there are exceptions for certain people to not have to follow those rules. And the Queen may be used to a custom in England where she doesn't need a driver's license. Rules don't apply to her. But folks, in the United States of America, we had a revolution for a reason. And under our Constitution, all people are equal under the law. At the end of this case, I expect that Judge Moore will give you an instruction to determine whether people used ordinary care, whether they were reasonable. The standard in this country is the standard of an ordinary person and their common sense. We don't make exceptions for kings and queens. Now, when someone drives drunk, runs a red light, uses their car as a weapon to injure another person, manipulates evidence, as we'll talk about in a minute, lies to police, and refuses to cooperate or give a breath test, people have to be held accountable. There are consequences. That's why we'll see the Queen was placed under arrest. And what we'll see in a few minutes is that the Queen wants to be held to a different standard than everybody else. And no one in this country is above the law. Let's look at some of this evidence here in a second. First slide. We have an independent, neutral eyewitness, no dog in the hunt, who made a statement to police that described the Queen hopping out of the driver's seat and switching places. So manipulating evidence, attempting to deceive the police. Also, Reagan also saw the Queen get out of the driver's seat and move around after the wreck. Next slide, please. Then the Queen refused to submit to a breathalyzer or drug test, citing her status as the head of the Commonwealth and defender of the faith. You may thought when I mentioned earlier in the story that I was making that up. That is a recorded statement documented by the police that the Queen did not believe she was subject to a drug test. She believes she is above the law. Next slide, please. The police, of course, disagreed and arrested the Queen and charged the Queen for driving while intoxicated. The Queen is not above the law, and only you 12 jurors in this case can make that decision and make sure that in this country no one is above the law and that we don't go back to the reigns of kings and queens who are not subject to the same rules as everybody else. Now, when you're the Queen of England and you think you're above the law, you can, of course, hire any lawyer you want. Money is no object. And Leon Carter, as you will see in a few minutes, ladies and gentlemen, is the best. Mr. Carter is a highly skilled trial lawyer, and you won't hear any arguments from me about that. So before we could bring this case to trial, there were several things we had to figure out. We knew that the Queen and her legal team would have a strategy to avoid justice. First one up, please. The Queen manufactures alibis, moves around to a different seat. They actually claim at the scene that the Queen was having difficulty breathing and Georgie was driving and he went through the red light because the Queen had a medical emergency. But folks, there was only one person transported to the hospital. It wasn't the Queen. It was the victim, Prince Larry. Queen was transported in handcuffs. The police didn't buy the alibi, and respectfully, I don't think we should either. Next, please. Don't cooperate with law enforcement. The Queen's lawyer may say, well, there's no positive breathalyzer test. Well, folks, the reason is the Queen attempted to behave as if she was above the law, and that is not an excuse or a get out of free pass to liability in the American court system. Next, please. And the most important strategy that kings and queens have used for thousands of years to avoid justice is to blame the victim. You'll hear all sorts of ways that the Queen will blame the victim in this case. There's evidence, as I mentioned early on, that Prince Larry was speeding. And there is also some evidence that Prince Larry was right at or slightly above the legal limit for alcohol as well. But here's the important thing. What you're going to be asked to decide in this case is, did the negligence of certain individuals cause injury to Prince Larry? Prince Larry's speed did not cause his injury. What caused his injury is the Queen ran a red light. In fact, if anything, Prince Larry's speed probably decreased the injury because as a faster moving car, it was a harder target for the Queen when she was attempting to use her vehicle as a weapon. And with regard to Prince Larry's alcohol, folks, he submitted to a breathalyzer test. He accepted responsibility for his actions and will have consequences to deal with the police as a result of that breathalyzer test. But that alcohol consumption did not cause the wreck and did not cause his injuries. And that's the question you're going to be asked to decide in this case. And we ask you to not let the Queen get away with an above the law strategy by deflecting from these facts or attacking Prince Larry, including trying to diminish Prince Larry's injuries, to try to say he's not really hurt as bad as he says. Well, folks, if the Queen's opportunity to diminish Prince Larry's injuries was to stay behind the red light, not press the gas, and not try to cause those injuries. And so we know that the Queen, out of anger, was attempting to cause harm to Prince Larry and to cause him injuries. And we can't accept an argument now that the Queen now wants to diminish what those injuries were. And with this, I now want to turn over to my co-counsel, Laura Geisler, to talk about damages, or in other words, the harms and losses caused by the Queen's lawless conduct.
Thank you. There is a story behind every scar. During this trial, you will hear the story behind this scar and the other harms and losses that Larry has suffered, and it will come through the evidence. Although the main characters in this story are members of the royal family, this is no fairy tale. Larry is just an ordinary man who is, because of this wreck, because of the Queen's negligence, has suffered significant injuries, harms, and losses. At the end of this trial, you'll be provided with a verdict form and asked to determine the amount of money Larry's damages are worth, and it's our job to give you a basis for that determination. Some of the damages, we know how much it will cost to fix. For example, what it will cost to pay his doctors for his medical care, his loss of income. Other losses are more intangible, such as his physical pain, mental anguish, disfigurement. Throughout this trial, though, we'll present you with evidence to support all of those damages so that when it comes time for you to make a determination and enter a verdict, you'll have a basis for determining those amounts. So let me tell you a little bit about the story behind the scar and the evidence that you will have to consider when evaluating the losses that Larry is claiming in this lawsuit. From the day Larry was born, he's been in the public spotlight. Larry's royal title predetermined his role in life. His title and royal tradition left him with little independence to make his own choices or have his own voice. It is a role where image is everything. And the image he was expected to project and protect was that of the Queen and her monarchy. Larry will tell you that he used to resent being a public figure, and he especially resented the paparazzi who he blamed for his mother's death. You see, his mother died in a tragic car wreck with paparazzi chasing her, trying to get a picture of her and her new boyfriend. Larry's perception of being a public figure and having a public image all changed when he met his wife, Reagan. She helped him see how he could use and control his public image for good through social media, how he could use his public image to champion charities and causes near and dear to his heart, like Wounded Warriors, an organization that works with disabled veterans. This is especially important to Larry since he is a veteran himself. Also, being with Reagan, a biracial American, opened his eyes to the royal privilege that Larry grew up with. This prompted him to decide to renounce his royal title and duties in recognition that all people should be treated equally under the law. This became even more important after the birth of their son, Archie. Larry wanted to be free to use his image and social media influence to endorse causes that the royal family felt were too progressive or too political. He wanted independence from the Queen, He wanted control of his own image. Larry's rising status as an influencer was also financially lucrative, allowing Larry the financial freedom to break free from the family royal business and support his own family on his own. Immediately prior to the wreck, Larry had lined up investors for the launch of his new lifestyle brand, Just Larry, a brand that the evidence will show is valued up to $20 million. He was very excited about starting his new life, independent and free of his royal duties. The decision to renounce his title was not easy. Larry did not want to upset his grandmother, the Queen, but he felt it was the right thing to do for himself and his young family. The evidence will show that Larry's decision to renounce his royal title was the reason why the Queen was so upset on the night of the wreck. She had found out that Larry and Reagan were in Dallas to publicly announce Larry's resignation and that he was meeting with investors to launch his new lifestyle brand, Just Larry. Larry and Reagan had hoped to get the Queen's blessing, but knew it wasn't coming until when she left the store opening without speaking to them. Larry will describe to you the horror and heartbreak he felt seeing his own grandmother gunning for him in her Rolls Royce, rage in her eyes as she rammed her car into his. The evidence will show that when the Queen rammed her limousine into Larry's vintage car, the glass in the driver's side window shattered to pieces and his face smashed up against the jagged edge of a broken window, slashing open, creating a big gash in his forehead, tiny shards of glass going everywhere, embedded in his forehead. Larry was taken to Methodist Hospital, treated for the lacerations and also for his neck and back injuries. He left that night, and not wanting to bring any more negative attention to his grandmother's arrest and ashamed by his parents, Larry delayed his announcement and canceled his meeting with investors. 3 days after the crash, Larry started physical therapy for his neck and back injuries. But once word got out of the wreck and his injuries, the paparazzi started stalking him on the hunt to get photos of his disfiguring injuries. This, of course, upset Larry. He was frightened and afraid for his safety and the safety of his young family, so they returned to Canada, where he continued physical therapy and resumed his recovery there. Now, when it comes to Larry's damages, you will hear a lot about his scar, the story behind the scar. You will hear testimony from Larry's doctor, world-renowned plastic surgeon, Dr. Alex Reisinger. Dr. Reisinger will describe for you what the advanced surgical technique she has used to minimize the visibility of Larry's scar and why at this point the disfigurement is permanent. She'll describe to you the long-term emotional and psychological issues associated with traumatic facial disfigurement. You will hear from Larry's psychiatrist, who will explain that Larry now suffers from post-traumatic stress disorder as a result of this traumatic facial injury. She will describe that he exhibits symptoms of depression, anxiety, insecurity, and a loss of self-worth. You'll hear testimony from Reagan about how the scar has affected, this facial disfigurement has affected Larry, how her once extroverted husband, who was the life of the party, is now withdrawn, refusing to leave the house, embarrassed to be seen in public. She'll tell you how once they got home from Canada, he removed all the mirrors from the house because he couldn't bear to see what he looked like. You also hear from Larry. He'll describe to you how the trauma from this wreck and the disfiguring injuries he had really has caused him to lose his will to live sometimes. He's so ashamed and embarrassed and angry, and it impacted him to the point where he just sometimes feels like he can't get back to where he was. And where he was on the cusp of having his own freedom and independence and living the life he wanted to live. He lost the opportunity he had presented to start his lifestyle brand, which resulted in a lost opportunity, which you'll hear about. Because the wound from the scar is not just physical and emotional. It came at a significant financial cost to Larry. You'll hear from expert witnesses who will explain how Larry's disfigurement has damaged his personal brand, resulting in a loss of $20 million in earning capacity. And while this scar plays a big part in the story, it isn't the entire story. The evidence will show that as a result of this wreck, Larry's injuries to his neck and back caused him constant pain. You'll hear from Larry's doctors who will tell you that there are conditions in his neck and spine from the wreck that conservative therapy, such as physical therapy, just won't fix. They'll tell you that he will have to live in constant pain for the rest of his life. And the best way to manage it will be with steroid injections that he'll need at a projected cost of at least $500,000. Now, he did have a prior back injury right before this wreck, but he had recovered from it. And the wreck likely exacerbated that injury, but he never had a prior neck injury. And to be honest, he never thought he would have to live this life in constant pain, not only the physical trauma, the scar and the disfigurement, but the constant pain of not being able to lift up his toddler son, not being able to carry him on his shoulders like he was before the wreck. It's just an insult to already open wound. Larry's doctors will tell you about his physical limitations now, what they anticipate they will be. And you'll hear from people in Larry's life that will tell you what they've observed, how it's changed him in significant ways. Now, I know that there are always two sides to every story, and Mr. Carter will likely present to you a very different story, one that minimizes the harms and losses that Larry has suffered, one that probably frankly just amounts to excuses. But remember, this story will be told by the evidence, and at the conclusion of this trial, I feel confident that you will know the full story behind the scar. Thank you.
Thank you. Mr. Carter, you may proceed.
May I proceed?
You may.
Thank you, Your Honor. May it please the court, Judge Moore, Ms. Geisler, Mr. Hamilton, ladies and gentlemen of the jury. As Mr. Hamilton said, and we will agree on this is a very important case. The whole world is looking at this case. People in this country, in Canada, in Europe, are looking at this case. And as Mr. Hamilton also said, there's a very simple question that you have to answer at the end of this case. And that question is it acceptable in this country, in this state, in our community, for a driver to drive 20 miles, almost 2 times the speed limit, while intoxicated and not have any responsibility whatsoever? That's what you have to decide in this case. Does the plaintiff bear any responsibility for the accident that occurred on February 15th, 2020? Now, Prince Larry has 2 outstanding lawyers. And as you've just heard, they did an outstanding job in telling you their side of the case. But as all of us know, and my grandfather used to tell me this since I was a little kid, a pancake, know whether if it's thick or if it's thin, has 2 sides. And so what I want to do in the 20 minutes that I have is tell you our side of the story. Now, as you know, the plaintiff goes first, and Judge Moore told you that in jury selection this morning, and the plaintiff just did his opening statement. And that is a huge advantage for anyone in any situation to go first. And why do I say that? Because study after study after study shows that 80% of the people believe the first thing they hear or the first thing they see. You just heard 2 outstanding lawyers for almost 30 minutes tell their side of the case. And I'm sure some of you have come to a conclusion already, even though you're not supposed to, but that's okay. That's okay. But they get a huge advantage. But you know why I can sit here unafraid? You know why my client can sit here, the Queen can sit here unafraid? Because there are 2 things that equalize the huge advantage that the plaintiff gets. One are the facts, and I can tell you, and the evidence is going to show you, that the facts are totally different than what Mr. Hamilton told you. And the second thing that makes it okay for us to sit here. And we've been waiting ever since this lawsuit was filed to come and tell you our side of the case. The second thing that makes it okay is that the plaintiff has the burden of proof. Not us, not the Queen, not Mr. Shufflebottom. We don't have the burden of proof, but we're going to bring you evidence that is going to be overwhelming to show you that what they said is not accurate. And I was kind of surprised that the theme for the plaintiff's case is that no one is above the law, because we agree with that. We agree 100% with that. But Prince Larry doesn't agree with that. The plaintiff's counsel's client does not agree with that, because I took his deposition and I asked him, now the speed limit at that intersection of Cedar Springs and Pearl, Prince Larry, was 30 miles an hour. And you were going 50 miles an hour. Isn't that correct? Yes, sir. And you know how we can prove that? And I'm going to talk about that in a minute. We have a video witness, not the video tape, a videotape, not some witness. We have a videotape that shows that. I said, now the fact that you were driving almost twice the legal limit, Prince Larry, do you accept any responsibility for the accident? Not at all. And Mr. Hamilton wants to say that their theme is no one is above the law. I said, okay, Prince Larry, you and your wife had been out drinking. You'd been at club after club after club drinking that night. And the police officer cited you for driving while intoxicated. Is that correct? Yes, sir, that's correct. I was over the legal limit. The fact that you were driving while intoxicated, Prince Larry, do you accept any responsibility for the accident? No, I do not. That's what he said under oath in his deposition. And I'm pretty sure he's going to say the same thing when he comes and testifies at trial. But yet, they want to tell you that no one is above the law, which is exactly what Prince Larry thinks in his mind. Now, before I start talking about the facts of the case, I want to tell you about the Queen, number 104, Mr. Glass. I want to tell you a little bit about the Queen. She's a fascinating person, and I must say I'm honored to represent her. And in my 30 years of practicing law, I can truly say that I've never met anyone with more elegance, more grace, and more class than the Queen. Now, there's a picture of the Queen and her driver, Mr. Shufflebottom. The Queen, as you can see, she was born April 21st, 1926. She just celebrated her 94th birthday. She married her husband, Prince Philip, in 1947, and they've been married almost 75 years. Now, the Queen, two interesting things about the Queen that I didn't know until she told me this. She's the longest serving monarch currently living, the longest serving. And this fact just blew me away. She's the longest serving female monarch in the history of the world. That's the Queen. And when we had our first conversation and I asked her about this case, I said, Queen, you know what? Why don't we just resolve this quietly? And she said, Mr. Carter, I can't. And I said, why? We could resolve this quietly, you know, without the negative publicity. She said, I can't do that. And then she asked me a question. She said, Mr. Carter, where were you in 1955 when President Dwight Eisenhower was the president of the United States? And I said, I wasn't here. I wasn't born. She said, okay. She said, but there's a quote that your president used in 1955 that will tell you the reason why I'm here and the reason why I'm fighting this. And that quote is, a people's who values its privileges more than principle will soon lose both. A people who values its privileges over its principle will soon lose both. So she told me, she said, Mr. Carter, This case is about principle. That's what this case is about. She said, 94 years, I have been living on principle. And there's another party in this case who's been living 30 years on privilege. So that's why she is here defending herself in this case. And she told me another thing that all of you all will relate to. She said, you know what, Mr. Carter, when you stand on principle, sometimes you lose a family relationship. Sometimes you lose a job. Sometimes you lose a promotion when you stand on principle. But at least at the end of the day, when you stand on principle and you stand on what you believe is right, you will never lose that. So that's why we're here. So what happened? Let me take you back to the incident that happened on February 15th. The Queen had arrived in Dallas to open up a new department store. And as the Queen does, she brought her chauffeur with her, Mr. Shufflebottom. Wherever she goes, she brings her chauffeur. Now, the plaintiffs want you to believe, and I want you to use your common sense here, but the plaintiff wants you to believe that this 94-year-old woman, and we will concede and readily admit at the opening of the department store, she had a couple of cocktails. But she wasn't driving and she didn't drive. But the plaintiff wants you to believe that she brought her chauffeur over here 2,000 miles across the Atlantic so that she could drive her vehicle on the streets of Dallas, someplace she had never been. That's what the plaintiff wants you to believe. But the evidence is not going to show that. Not even close. What the evidence is going to show is that on the evening in question, about 11:30 at night, while she was at the function, she got ill. She became ill, and she had some breathing issues. And she quietly and discreetly went to her chauffeur, Mr. Shufflebottom, who has been driving her for 30 years, and said, you know what? I need you to take me to the nearest hospital because I'm not feeling very well. So they quietly left the department store. Mr. Shufflebottom puts her in the backseat of the car where she's resting comfortably until they get to the hospital. He takes the wheel, and he hasn't been in Dallas before either. So he approaches the intersection of Cedar Springs and Pearl, and the evidence is indisputable. And you know why I say that? I'm confident in saying that? Because there's a videotape, not a witness, not my clients, but a videotape will show that what Mr. Shufflebottom did at that intersection in question was stopped at the red light. He came to a complete stop. And because the Queen was in medical distress, the light was red. There's no doubt about that. We will readily admit the light was red, but he came to a complete stop and he looked both ways and proceeded slowly through the red light because of the medical emergency. And at that time, because Prince Larry was driving over twice the speed and driving while intoxicated, he hit the Queen's vehicle. That's what happened that night. Now, Mr. Hamilton wanted to say that, well, the Queen was intoxicated and she got driving while intoxicated, arrested for driving while intoxicated, and you know what? She did. But once the police conducted an investigation after this incident, which included the videotape, they saw that she wasn't driving and she shouldn't have gotten to drive while intoxicated. So those charges were dropped. Now, Mr. Hamilton didn't tell you that, and that's okay. Maybe he just forgot that. That's what happened on February 15th. Mr. Shufflebottom was driving that vehicle, and because of a medical emergency, he stopped at the light and was going through that red light to get the Queen to the doctor. So what you have to decide is whether or not it was reasonable for Mr. Shufflebottom to initially stop at the red light, and then proceed through the red light because of the condition of his queen. That's what you have to decide. And what you have to decide is whether or not it was acceptable for Prince Larry to drive almost twice the legal limit, which you will see the law in this state that if a driver is driving 20 or more miles over the legal limit, that driver is engaged in reckless conduct. So what you have to decide is whether Prince Larry, who was engaging in reckless conduct while intoxicated, if that's acceptable in this community in Dallas, this is what I want you to do. I want you to give Prince Larry every penny they ask for, if you find that that's acceptable in Dallas County, Texas. However, if you find, which I think you are, that that's not acceptable, and that Prince Larry should bear at least some or all of his responsibility for this accident, you don't give him a dime. And you let him know the reason why you don't give him a dime. Now, Ms. Geisler talked a little bit about the fact that Prince Larry had a prior back injury. She didn't talk very much about that. But I want to tell you a little bit about the back injury, because their main claim, I know Prince Larry has a scar, but their main claim is that Prince Larry had a back injury, therefore he can't work again. He can't do anything. So therefore he deserves $20 million. You heard Ms. Geisler say that. They're seeking $20 million because they're claiming he sustained a back injury. And the first thing about that is that the car, 115, Mr. Glass, the car in question, the accident, when the police investigated, they said this was a minor traffic accident, and there's the right side of Prince Larry's Aston Martin, and that shows the damage to the vehicle that he had. That's an actual picture that the police officer took. And in the police report, which you're going to see in evidence, it states that there was minor impact with the vehicles. But the thing that I scratched my head about when I thought about this case, he's claiming a severe back injury, but the accident happened from the side, not the back. And you saw the minimal damage on the car. That's what he wants you to believe, that he was hit from the side and all of a sudden it caused a back injury. Ladies and gentlemen, we talked about this in jury selection. Don't leave your common sense at the door. That's all you need in this case. You don't need a PhD, you don't need a college degree. All you need is just a little common sense. And what they're claiming doesn't make sense. It doesn't make good sense, and it doesn't make common sense. Not at all. But what Ms. Geisler didn't tell you, nor Mr. Hamilton, is that about 6 months before, in late 2019, Prince Larry was riding one of his prize ponies, and he fell and suffered a horrible injury to his back. Was hospitalized for weeks, couldn't get out of bed. A horrible, horrible injury to his back. She didn't tell you that. She made a fleeting reference to that. And so what this lawsuit is about, and I don't mind telling you, this is an ingenious lawsuit by Prince Larry. This is ingenious. So he falls off his horse, has a severe injury to his back, and he can't sue his horse, and he can't sue himself for $20 million at that time. So what does he do? He waits for the right opportunity. February 15th, 2020. And as his attorney, Mr. Hamilton, said, he went to the doctor by ambulance that night, went to the hospital. But the evidence will show, did he go back the next day? No. Did he go back the second day after the accident? Nope. 3 days after the accident, and I think the evidence is going to show this. Once he and Miss Reagan realized that they could take advantage of this opportunity, they went to Dallas Rehab to see a specialist and said, this is our meal ticket. This is what we can claim caused my debilitating back injury. Not the injury I had on my pony, but this accident, this side accident is what caused me to have a back injury. That's their story, and they're sticking to it. But what happened when he went to Dallas Rehab? I don't think Ms. Geisler told you this, and I think the evidence is going to show this. They're claiming 3 days after the accident, had a horrible back injury. They go to the best doctors in Dallas, and the best doctors in Dallas tell them, you need 5 weeks of intensive therapy, of intensive treatment. And after 5 weeks, you're going to be good as new. But you got to follow the regimen. You got to do what we tell you to do. If you are saying that you're in as much pain as you are, you need this 5 weeks of intense treatment. What is the evidence going to show that Prince Larry did? Maybe the evidence is going to show he went for 4.5 weeks. No, it's not going to show that. Well, the evidence is going to show he went for 4 weeks for his treatment because he was in such pain. No. Well, he went for 3 weeks for treatment because he was in such pain. No. Well, wait a minute. He's seeking $20 million for a back injury, indicating and stating that he's going to have spinal injections the rest of his life, and he doesn't follow the doctor's instructions. He went for 2.5 weeks. No. He went for 2 weeks. The evidence is going to show. And then he and his lovely bride got on a plane, went to their villa in Canada, and what did Prince Larry do at that point? He went to his own personal guru for back treatments.
Leon, we're running out of time. I'm so sorry.
That's okay, Judge. Thank you. Who was not a doctor, who was not a medical care provider, but that's what he did. So, ladies and gentlemen, this case is real simple. Was the conduct engaged in by Prince Larry acceptable? If it was, like I indicated, give him $20 million. Give him every penny. But if you find, and I know the evidence will show, that he bears most of the responsibility for this accident, if you find that, you should not award him one single dime. And do as the Queen said, let him know that this is a country of principle, that we will stand up when we're right, that we will fight when we're right, no matter the cost. Thank you for your time.
So I apologize. We are totally out of time, Judge Moore. We have to get to the other room. This was a fantastic presentation. I did want to thank
everyone.
Yeah, great job, everyone. I wish we had another hour with you guys because that was fantastic. I need to thank a couple other people, John DeGroot, who put this whole thing together. Fantastic job of coordinating all of the technology. Sherry Harris, who's our wonderful executive director for the DAYL. George Pattis, who helped coordinate all the speakers and is one of the vice chairs of the committee. And then Marifed Acebas, who is one of our committee members, I forgot to mention earlier. Fantastic presentation. You will see in the chat function we have the link to the other portion of this. As you all know, we have a participatory learning, experiential learning component of this that is an incredibly important part of this. Even if you aren't going to be part of the experiential learning, we encourage you to go to the other link. Again, it's in the chat. It should be a great presentation. I think Chris Hamilton and Laura Geisler are both going to be joining us in that and going to be helping to evaluate the young lawyers who are going to be making presentations. I want to thank all of my interns who are going to be also assisting with that. This was a very, very well attended program, and we look forward to again, the link is in the chat. You can go directly to the other portion. Leon, Chris, Laura, wonderful job. Judge Moore, wonderful job. Thank you so much, and we're going to go ahead and end this portion of the presentation. Thank you.
Thanks, everybody.
Thank you. Thank you, guys.
Thanks all. Great job.
Thank you, sir.